Sexual Harassment Prevention in Maryland. The Maryland Commission on Civil Rights, or MCCR, represents the interest of the state to ensure equal opportunity for all through enforcement of Titles 20 of the State Government Article and 19 of the State Procurement and Finance Article, Annotated Code of Maryland. MCCR investigates complaints of discrimination in employment, housing, public accommodations, and the state's commercial non-discrimination policy from members of protected classes that are covered under these laws. What is a protected class? Every Marylander is guaranteed equal opportunity in employment and in all labor management union relations regardless of race, color, religion, ancestry or national origin, sex, age, marital status, sexual orientation, gender identity, disability, or genetic information. What is harassment? Harassment is unwelcome conduct that is based on a person's protected class. Harassment becomes unlawful where 1. Enduring the offensive conduct becomes a condition of continued employment, or 2. The conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Anti-discrimination laws also prohibit harassment against individuals in retaliation for filing a discrimination charge, testifying, or participating in any way in an investigation, proceeding, or lawsuit under these laws, or opposing employment practices that they reasonably believe discriminate against individuals in violation of these laws. Petty slights, annoyances, and isolated incidents, unless extremely serious, will not rise to the level of illegality. To be unlawful, the conduct must create a work environment that would be intimidating, hostile, or offensive to reasonable people. What is sexual harassment? It is unlawful to harass a covered applicant or employee because of that person's sex. Sexual harassment can include unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. Both the victim and the harasser can be either a woman or a man, and the victim and the harasser can be the same sex. The harasser can be the victim's supervisor, a supervisor in another area, a coworker, or someone who is not an employee, such as a client or customer. There are two forms of sexual harassment: quid pro quo and hostile work environment. Quid pro quo. Quid pro quo translates from Latin to English as this for that. The basic idea is that of an exchange. I do something for you, and you, in turn, do something for me. Offering something work-related in exchange for a sexual favor is sexual harassment. For example, say your boss promises to give you a raise or a promotion if you have sex with him or her. That would be quid pro quo sexual harassment, and it would be illegal. Hostile work environment. Hostile work environment sexual harassment occurs when an employee is subjected to unwelcome advances, sexual innuendos, or offensive gender-related language that is sufficiently severe or pervasive from the perspective of a reasonable person. This type of harassment must be sufficiently severe or pervasive so as to alter the conditions of employment and create an abusive environment. A single instance of sexual harassment in the hostile work environment context may be sufficient if the conduct is severe enough. A single instance of sexual assault may be sufficiently severe enough to constitute a hostile work environment. Sexual harassment can be physical or verbal. Examples of physical sexual harassment include touching, grabbing, and pinching, being cornered, sending sexually explicit emails, pictures, or notes, sabotaging a person's work, making suggestive gestures or facial expressions, viewing pornographic materials, removing clothing, sexual assault. Examples of verbal sexual harassment include making suggestive or sexual remarks, jokes, or noises, using demeaning or inappropriate terms such as babe, spreading sexual or suggestive rumors, making a sexual proposition, using crude or offensive language such as stereotypes. Case Law Overview. Meritor Savings Bank, FSB, versus Vinson, 1986. In Meritor Savings Bank, FSB versus Vinson, 1986, the Supreme Court first held that Title VII protects against sexual harassment where the conduct is severe or pervasive enough to alter the conditions of the victim's employment. To be actionable, the environment must be both objectively and subjectively offensive. In other words, the environment must be one that a reasonable person would find hostile or abusive. Farragher versus City of Boca Raton, 1998, and Burlington Industries, Inc. versus Ellerth, 1998. In this pair of cases, the Supreme Court established a new standard for imposing vicarious liability on employers. Vicarious liability arises from the relationship between parties rather than from fault. It means that responsibility is imposed on one party because of actions committed by another. This means that the employer may be held liable for the actions of a supervisor, even if the employer was not made aware of the conduct. A supervisor is legally defined as someone with power to hire and fire, significant control over the employee even if they do not have ultimate authority, authority to affect the terms and conditions of employment. An individual with the responsibilities outlined above may be considered to be a supervisor under the law even if they do not have an official supervisory position or title. When there is a tangible employment action by a supervisor, such as termination, demotion, or undesirable reassignment, the employer is liable for the supervisor's discrimination, regardless of whether the employer approved, knew, or should have known of the supervisor's actions. A tangible employment action is a significant change in employment status. Examples include hiring, firing, promotion, demotion, undesirable reassignment, or a decision causing a significant change in benefits, compensation decisions, and work assignment. An employee does not need to show economic harm to prove that they were subjected to a tangible employment action. For example, demotion is a tangible employment action, even if the employee's salary is unaffected. When no tangible employment action is taken, or when the harassment is not perpetrated by a supervisor, an employer may raise an affirmative defense to liability or damages. An affirmative defense is an argument or new information put forward by an employer that mitigates the legal consequences for the employer, even if what the plaintiff alleges is true. Farragher and Ellerth established the following standards for an affirmative defense. If an employer can prove that it exercised reasonable care to prevent and correct harassment, such as thorough prevention efforts, adequate complaint procedures, adequate responses to complaints to prevent and promptly correct any sexually harassing behavior, and that the employee unreasonably failed to take advantage of the corrective or preventative opportunities provided, or to otherwise avoid harm. This may mean that the employee failed to provide notice to the proper party, such as a supervisor, failed to report the harassment or delayed, or failed to avoid the harm. Employers are not vicariously liable for harassment by coworkers. In these cases, employers are liable if they knew or should have known about the harassment and failed to act, or were negligent. It is important to note that employers may still be liable for damages even if the victim never complained to the company, if the investigating supervisor or officer did not pursue it because the victim requests confidentiality, or if the victim perceives that their own opportunities are impeded by the manager's harassment of or consensual relationship with another employee. Legal updates. During the 2018 and 2019 legislative session, updates were made to Maryland's laws against sexual harassment. Here are some of the important changes. Independent contractors and individuals chosen by an elected officer to be on the officer's personal staff are protected under Maryland's laws against sexual harassment. Maryland law defines an employer for purposes of harassment claims only as having one or more employees for each working day in each of 20 or more weeks. The definition of supervisor has expanded. Employers are liable for acts committed by an individual who undertakes or recommends tangible employment actions, directs, supervises, or evaluates the work activities of the employee, or if the negligence of the employer led to the harassment or continuation of harassment. In addition, the statute of limitation to file a complaint of harassment with MCCR changed from 6 months to 2 years after the date on which the alleged harassment occurred, and the time limit for civil action or court filing changed from 2 years to 3 years after the alleged harassment occurred. Thank you. We look forward to working with you to accomplish our vision to have a state that is free from any trace of unlawful discrimination.